You've got Kesha Lewis.
Right out of the gate. This may sound routine, but don't let the calm tone fool you. We're about to watch a deferred probation case unravel in real time. And when someone on probation is back in court, that usually means the stakes just got very real.
Yes, ma'am, I just printed her.
Judge, I do have an update for you whenever on Mr. Flynn's case for next week.
On whose?
Be behind Mr. Flynn from yesterday.
Oh.
The one you allowed me to make a phone call.
Oh, good, good.
It's on mistaken felony.
Okay. Good morning. Are you Kesha Lewis?
Yeah. Judge,
Pause right there. This might sound like minor wordplay, committed versus arrested, but legally, that distinction matters. Committed focuses on the act itself, not just the arrest. And in probation revocation hearings, the burden of proof is lower than in a criminal trial. Translation? The state doesn't need a brand new conviction, just enough evidence to show she violated the terms. That's a powerful procedural advantage.
may I just ask the court two things before we proceed?
Yeah.
Can I make an oral motion to amend counts 1 through 4 and each motion to reflect committed the offense rather than arrested? We have discussed that upstairs, and everything that's been filed subsequently is correct.
Okay.
So I think
It's if y'all catch them ahead of time, it's much easier for y'all to do it than me to try to do it on this computer. But yes, any objection to that? In each of the cases are the same.
No objection.
All right, let me get these printed out. It'll be easier.
Did you catch that? Enhancement purposes. That's legal code for. This could make future charges worse. Prior convictions can increase sentencing ranges dramatically. So what we're hearing isn't just paperwork housekeeping, this is record building. And records follow you everywhere in the criminal justice system.
Sorry, it's taking me just a minute.
And Judge, also it is my intention, if the court follows this agreement, to have her plea to all 4 of those misdemeanors down the hall so that we can use them in the future for any enhancement purposes, and also to let you know I've spoken with her probation officer, Mr. Alex Hill, and he informs me that her case in Galveston County, that interfering with an emergency service animal, she did plead guilty to that, and they sentenced her to 1 year.
Thank you. 2 motions. Thanks. Okay. Let me make these amendments first.
Waiving the formal reading is common, but symbolically, it's significant. It means she's not contesting the allegations line by line. We're moving straight to substance. And when that happens in a revocation hearing, it often signals one thing: a negotiated outcome is already in motion.
And thank you for talking to them and getting these changed. All right, let me. Today's the 3rd.
Some of it may have been just a misunderstanding for privacy.
Okay. Now, will your client waive the formal reading of the motion in each case?
She will, Your Honor.
Ms. Lewis, in cause number 22-40529, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 25th of 2023 for the second-degree felony offense of robbery, and that was a 7-year deferred probation. Is that correct? I'm sorry?
It was a 6-year probation.
Hold on, I'll go back and double check.
I think it's actually 7, Your Honor.
Administrative hearing shows 7.
The deferred adjudication order dated January 25th of 2023 also shows 7 years. All right, so you were placed on probation January 25th of 2023 for robbery, correct? Okay. And in cause number 22-40528, looks like there is a first amended motion to revoke your unadjudicated probation in that case. Shows you were placed on probation January 25th of 2023 for assault on a peace officer, a second-degree felony, and that was also a 7-year deferred probation. Is that correct? Should I have a first amendment in each of these? Did I? Hold on a second. 5, 2, 9. Yeah, hold on. Let me. I printed out the wrong thing. Sorry.
But all the amendment added was that case in Galveston.
Okay. I just want to make sure. It just lines up the numbers better if I have them both, the right ones. I need that motion there just printed, please. Each of these cases, looks like the state is going to proceed on counts 1 through 6 in each of these cases. Count 1 in each of your cases, or in each of the motions, alleges that you committed the new offense.
Listen to how fast that happened. 6 allegations. 6 true responses. In a probation revocation hearing, just one violation is enough to revoke. She admitted to all 6. At this point, the question isn't if probation will be revoked, it's how much time she's about to face. And remember, this was originally deferred adjudication. That means if revoked, the judge can now sentence her anywhere within the full statutory range for the original felony.
Offense of evading arrest or detention, March 12th of 2025 in Jefferson County, Texas. And is that true or not true? I'm sorry?
True.
And then count 2 in each case alleges that you committed the offense of resisting arrest, search, or transport, March 12th of 2025. And is that true or not true?
True.
Count 3 in each case alleges that you committed the offense of theft of property, March 12th of 2025 in Jefferson County. And is that true or not true?
True.
And then count 4 in each case alleges that you committed the offense of failure to identify or giving false or fictitious information. And is that true or not true? That's also on March 12th of 2025. And that's true as well?
Yes, ma'am.
Count 5 in each case alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
And then count 6 in each case alleges that you failed to provide verification of entering and
For years and 4 years, but concurrently. That means she serves them at the same time, not back to back. If they ran consecutively, we'd be talking 8 years. So while this is a prison sentence, it's also a negotiated cap on exposure. Still, this is the turning point. Deferred probation is gone. The court has now formally adjudicated guilt.
successfully completing the anger management program. And is that true or not true? Did you enter your pleas of true to counts 1 through 6 freely and voluntarily?
Yes.
And did you plead true to all of those counts because they're actually true?
Right.
I have here on the tablet in each of your case some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
And do you fully understand them?
Yes.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
State tenders number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Ms. Lewis is not competent?
No, Your Honor.
All right, ma'am, in each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true, and cause number 2240529, find sufficient evidence to find you guilty, and at this time find you guilty of robbery. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 2240528, also find counts 1 through 6 true, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with that agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you the trial court certification in each of your cases that shows that these were agreements that I followed, and so you've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. Good luck to you, ma'am. You can go back with the bailiff.